very good day to everyone. We are from Genevieve and Co. Our firm is assigned by the Legal Aid Center with pro bono case to represent Jimmy, who is the accused with the possession of drugs at the Magistrate Court of Jitra. Jimmy has pleaded guilty and the magistrate according to the fixed 4 July 2023 for the fact and sentencing proceeding. We would like to have a plea of mitigations for leniency in the sentence that is to be imposed on Jimmy. Before that, let me explain what is mitigation factors. A plea of mitigations is when the accused asks for the court for leniency in sentence. Mitigating factors may be include family backgrounds, education qualifications, medical history, employment history, and any other relevant factors. The plea in mitigations is central to the sentencing process. There is no provisions for the criminal procedure court for the plea in mitigations. However, it is established practice to allow a plea in mitigation before a sentence is passed. The Thomas said in his book entitled Principles of Sentencing at page 39, in the case of Dr. Sri Anwar Ibrahim, from the initial figure calculated by reference to the seriousness of the offence, allowance may be made by the way of mitigations for good character or moderate good character. However, in assessing the allowance to be given from my calculations of the initial figure, I had to strain myself to look for mitigating circumstances in favor of the accused. In the absence of any plea in mitigation from him or his counsel.
Dengan segala hormat Tuan Magistrate, mohon izin mahkamah untuk menggunakan bahasa Inggeris bagi tujuan hujahan mitigasi.
Counsel diizinkan.
Terima kasih, Tuan Magistrate. Upon the facts of the case, we as the counsel for the accused would submit the first mitigation factor for the accused, which is his plea of guilt. The general rule is that the court will give the accused a credit or discount for entering an early guilty plea for the offence. This is in lieu of the fact that the plea of guilt not only saves the country a great expense of a lengthy trial, but also saves time and inconvenience of many, particularly the witnesses. With this, we humbly refer to section 172G of the Criminal Procedure Code. As such, it states that if the accused pleads guilty at any time before the commencement of his trial, the court shall sentence the accused in accordance with section 172D subsection 1C2 of the CPC, in which the sentence on the accused should not be more than half of the maximum punishment of imprisonment provided under the law for the offence of which the accused has been convicted, and this is subject to subsections 2 and 3 of section 172D of the CPC. In the course of trial, there is no fixed rule as to the discount or reduction, but it is usually reduced between a quarter to 1/3 of the sentence that would be imposed. With this, we humbly refer to the case of Muhammad Abdullah Ang Swee Kang against PP in 1987, where the Supreme Court stated that the accused's guilty plea also allows the court to exercise discretion to give a discount or reduction of 1/4 or 1/3 of the sentence, which would be imposed after a full trial. In the recent case, although Jimin did not plead guilty to the charges upon the first reading of the charge, Jimin subsequently pleaded guilty at the earliest opportunity he had, which is during the mention of the case on 4th June. Jimin reasonably did not understand the concept of plea of guilt as he was unrepresented during the reading of the charge. However, upon advice from his counsels, the accused decided to plead guilty to the charges. With this, we hope that the court would consider his plea of guilt being at the earliest opportunity as a mitigation factor.
Since the accused plead guilty, these are factors that we humbly request for the court to take into consideration during the mitigation process before imposing sentence to the accused. To our magistrate, we plead that the court to take into consideration of Jimin's health condition, whereas he is diagnosed with diabetes stage 2. According to the previous principle in the Thai Chuan Bank and another case, the court, in assessing the sentence, the court took into account the second accused background and also secondary report. Due to that, since Jimmy was diagnosed with diabetes stage 2, it is reasonable for him to search for other alternatives such as traditional way to overcome his illness, while he was collecting money for proper medical care, and he found it accessible to get the treatment instead of going to a big hospital that is far away from his home, which is 50 km, as the clinic kesihatan can only provide with minimal care. Not only that, Tuan Magistrate, the sister also plans to send him to a private drug rehabilitation center and later also get treatment on a voluntary basis at Clinic Cure and Care AADK after they have collected enough money to cover the expenses. Tuan Magistrate, this proved that our client and his family tried their best despite their financial condition to cure Jimin. Not only that, we also would humbly request for the court to take into consideration of Jimin's age. Tuan Magistrate, Jimin is still young. According to the provision provided under Section 2 of CPC, youthful offender means a person convicted of an offence punishable by fine or imprisonment who is or above the age of 18 or below the age 21, and in addition, as stated in Section 293, subsection 1, for youthful offenders, instead of sending him to prison, the court may order him to be discharged after due admonition be delivered to his parents. For that, counsel making reference to the case of Teo Siu Peng against persecution, where the previous court in this case stated that they strike law that in the case of young offender there is no conflict between the public interest and that of the young offenders. The public has no greater interest than that young offenders should become a good citizen. And later it was further affirmed in the case of Tukiran BINTI, where in this previous court, the previous court held that it is desirable that young offenders, that is offenders between the age of 17 to 21 who are the first offenders, should be kept out of prison if possible. With that being said, Tuan Magistrate, we believe that Jimin still has the potential and can do much more if he is being given a second chance. Above all, Jimin's sister also vouched and also reassured us that the accused himself is being removed because he is trying to help lessen the burden of the family on his medical spending and ensure that he has strong interest and talent in business. We believe that everyone deserves a second chance if given to a magistrate. Thank you.
Dengan izin Tuan Magistrate, based on the facts of the case, it is established that Jimin had committed offences under Section 6 and Section 15, Subsection 1, Subsection A of DDA 1952 precisely for possessing cannabis weighing 0.16 grams and self-administration of drugs. On behalf of the accused, we would like to request for leniency in sentence from the court in the aspect of nature of offence. It can clearly be adduced from the charges that both of these offences are not serious offences. It also does not cause any grievous hurt to any persons, nor endangering someone's life. The drugs found could only harm the accused, but not society. This is because such possession was clearly used for himself and not to be transacted to anyone. Thus, these offences clearly are not serious and not probable to cause harm to the public. Reference can be made in the case of Hu Chi Kyong against PP, where the accused committed an offence under Section 474 Penal Code, punishable with imprisonment up to 7 years, or may extend to 20 years if documents purported are those mentioned in Section 467 of Penal Code. Here, the court substituted 3 years of imprisonment by taking into consideration that the offence committed did not involve any violence, nor the accused caused heavy financial loss to anyone. Likewise, we also seek leniency from Tuan Magistrate in ordering sentence for the accused in the present case.
Tuan Magistrate, I would also like to highlight the significant role that family plays in the life of the accused. The accused is the sole male member of the family. Following the untimely demise of the parents, it has brought a profound impact on the accused's family dynamics. He had no choice but to leave the school while he was in Form 3 and help his sister in the restaurant business. The accused is the main reliance of his only sister. He endeavors to maintain the stability of their life and provide protection to his only sister. Without the accused in the family or imposing overly harsh fines would not only impact the accused but also exacerbate the hardship already experienced by his sister. Alternatively, if Tuan Magistrate does not accept the problem of hardship on the accused family as a mitigating factor, as in the case of Lo Chun Fat, I implore the court to consider the approach established by the same case, namely balancing the interests of the public with the interests of the accused in assessing the weight of sentence. As stated earlier, the cannabis found on the accused was purely self-administration based on his personal health belief. The relatively small quantities of cannabis found are not so grave as to justify stern consequences to be imposed with the name of preserving the public interest. Therefore, I respectfully request Tuan Magistrate to take into account the effect of the sentence to his family and the balance of interest submitted earlier in your deliberation. Much obliged.
Tuan Magistrate, remorse or repentance after the commission of the offence is a valid factor in mitigations. To determine whether the accused regrets what he has done, it can be showcased by the behavior of the accused after the commission of the offence. If I may draw the court attention to the case of Kasavan Sindaran, in this case, the accused has met to tackle the problems that led him to commit the offence. The court held that such positive steps include cooperation with police investigations, pay voluntary compensation to the victim. If the accused is an alcoholic or drug addict, it can be mitigated if he voluntarily attends treatment classes or counseling. Tuan Magistrate, in our present case, the accused ready to go for a private drug rehabilitation center. In the furtherance, the accused will also get the treatment on voluntarily basis at Clinic Cure and Care. Hence, we submit before the court that the accused behavior after the commission of the offence should be considered for mitigation.
In a nutshell, the mitigation process is seen as a ray of hope for those who has been convicted, because no one is purely evil and some might be doing the act of crime at that spur of moment. However, nevertheless, there is no denying that crime is bad, and for those who committed it shall receive punishment accordingly. I think that is all from Genevieve and Co. Thank you.